order the planning board meeting of April 11th, 2023 for the city of Summerside. I'll begin by calling for a motion to approve the agenda as presented. I'm going to think that only Councillors Duran and Snow can, because it's planning board. So I think it has to be moved by Councillor Snow, seconded by Councillor Duran. Any opposed? Me, I'm not opposed, so we will carry the agenda as presented. Conflict of interest declaration for anyone here. I guess again, Councillors Duran and Snow are the members of planning board. We still have a planning board vacancy until our next council meeting. But if there's any declaration of conflict of interest from any councillor who is joining us today, you can let me know. Hearing none, we'll move on. We acknowledge the land upon which we gather is the unceded Mi'kmaq territory. Abogway is covered by the historic treaties of peace and friendship. We pay our respects to the indigenous Mi'kmaq people who have occupied this island for over 12,000 years, past, present, and future. At this point, I'll hand the meeting over to Councillor Duran, Chair of Planning Board.
Thank you, Your Worship. We will get right into it, I guess. Item number one is 130 Greenwood Drive. It's just a correction from the April 4th, 2023 meeting. A correction is required to be read into the record for the Planning Board recommendation regarding the application for 130 Greenwood Drive, read at the April 4th, 2023 Planning Board meeting. The recommendation read at the Planning Board meeting on April 4th is as follows. So this is the incorrect version. The application received from Camco Inc. for PID number 69781 to amend the city official plan from industrial land use to residential land use, and the zoning bylaw from light industrial M1 zone to a mix of low density mixed residential R2 zone and high density residential R4 zone be recommended to be approved by council. The corrected recommendation to be read this evening. The application received from Camco Inc. for PID number 69781 to amend the city official plan from industrial land use to a mix of commercial and residential land use, and the zoning bylaw from light industrial M1 zone to a mix of low density mixed residential R2 zone, high density residential R4 zone, and medium density narrow lot residential R3R zone be recommended to be approved by council. And there's nothing we have to vote on or anything there. That was just a correction to be read into the minutes. So I'll move on to recommendation for 373 Jennifer Street, a major variance. Purpose of the major variance is to allow lot frontage variances for two proposed single-family lots. Background: an application was received from IPAX Inc. to create two lots from an existing semi-detached lot, PID number 937771 at 373 Jennifer Street in the R2 zone. The existing semi-detached lot, 30.6 meters lot frontage, was created under the previous zoning bylaw. The lot frontage requirement for a semi-detached under the current zoning bylaw is 26 meters. The applicant is proposing to create two single-family lots, each with a lot frontage of 15.3 meters. The report. Single-family dwelling lots in the current R2 zone require a lot frontage of 21 meters. The lots to the south of the subject parcel were developed under the previous zoning bylaw, which allowed linked dwellings requiring a lot frontage of 15.3 meters. The applicant is requesting approval of a variance of 27% to the lot frontage of two lots. Justification for the variance, as required by section 7.2 of the city zoning bylaw SS 15, 2007. Council, Planning Board, and the Development Officer shall consider the variance against the following tests for justifying a variance. A, that the hardship is due to unique physical conditions of the lot or property, including small lot size, irregular lot shape, existing building location on the property, or exceptional topographical conditions, which make it impractical to develop in strict conformity with bylaw standards. Exceptional topographical conditions may include but are not limited to trees, slope of the land, etc. Staff comment: yes, this variance request would meet this test. The lot was created under a previous subdivision and site development bylaw, and the lot is now being incorporated into a new subdivision lot layout under the current bylaw, which creates a hardship as the property lines for the existing lot R2 are existing. B, that the proposed variance meets the general intent of the official plan. Staff comment, yes, this variance request would meet this test. The existing lot land use is residential. C, that the proposed variance meets the general intent of the zone. Staff comment, yes, this variance request would meet this test. The proposed single-family lots will be required to meet the front, rear, and side yard setbacks of the R2 zone for single-family housing. D, that the proposed variance would not impact negatively on adjacent properties or on the essential character of the surrounding neighborhood, including taking into consideration any comments from neighbors. Staff comment, yes, this variance request would meet this test. 12 letters were delivered to 9 properties within 30 meters of the boundaries of the subject property. The deadline for written comments was April 6, 2023. No written comments were received in regards to the variance specifically. The variance will not impact the required setbacks on the existing neighbors. The variance impacts the proposed single-family dwelling lots only. The setbacks to property lines will be required to meet the R2 zone. Steve Zimmers of 372 Norman Drive expressed concerns with pedestrian traffic en route to the tax center, crossing his property and the property that is proposed to be subdivided at the end of Jennifer Street. Mr. Zimmers requested council consider a public pedestrian walkway as part of the proposed subdivision at the end of Jennifer Street. The city's zoning bylaw provides regulations for the uses of land and location of buildings on a property. It is difficult for zoning bylaw provisions to take into account all circumstances such as pertaining to lot sizes, lot shapes, pie-shaped lots, property line, yard setbacks, or topographic conditions, which may impact the development of a particular property. The hardship for a variance cannot be an economic one, but must be technical in nature. The size and shape of the property or the design of a building or project may prevent the owner from fully meeting all of the provisions of the zoning bylaw. In such cases, a variance is a mechanism which is used to provide some degree of flexibility and discretion in applying the strict provisions of the bylaw. As a general principle, a variance must maintain the general intent and purpose of the zoning bylaw. It should never be used as a mechanism to circumvent or frustrate the intent of the bylaw. For example, a variance cannot be used to create a land use or to fully eliminate a required yard setback. Any person who is dissatisfied by a decision of council or the development officer made under the zoning bylaw may appeal to the Island Regulatory and Appeals Commission within 21 days of the decision in accordance with the Planning Act. Staff review. Staff support the lot frontage variance of 27% for 2 proposed single-family dwelling lots at 373 Jennifer Street. As per section 5.10 part B3 of the zoning bylaw, the planning board shall make a recommendation to council on this application before it is approved or denied. The planning board recommendation, whether carried or defeated, will be brought forward for council for a final decision. Planning board recommendation, the application from IPAX Inc. for PID number 937771 for a lot frontage variance of 27% for 2 lots be recommended to be approved by council. Moved by myself and seconded by Deputy Mayor Snow. Are there any questions?
So I think I heard it clearly. So the lot, whatever's gonna be built on that lot moving forward, still have to have the same setbacks as they would on any other size lot. There's not gonna be, it's not gonna affect neighboring properties by the lot being smaller.
No, it won't. What they're proposing here, just shown on the sketch,
Yeah.
they'll meet all of these side yard
Right.
setbacks, rear setbacks, and front yard setbacks. I just wanted to point out as well that those lots, like I say, were just to the south of this, were developed under a zoning. It was allowance for linked dwellings. So these lots below it are all that size now. So these 2 lots will blend right into it, as well as the other 2 that they're proposing.
So it's a continuation of the exact same thing that has been happening in that area.
Yep, correct.
Okay, I guess we will call for the vote from planning board. All in favor, say aye. Aye. And everyone's here, so there's no opposition. Carried. Next item, recommendation for 480 Central Street for a mobile sales establishment. Supporting explanation, purpose. The purpose of the application is to allow a mobile sales establishment, Big Guy Burger and Fry, to operate at 480 Central Street. Background, purpose of the application is to allow a mobile sales establishment, Big Guy Burger and Fry, to operate at 480 Central Street, weather permitting. The proposed hours of operation are 11 a.m. to 7 p.m., Monday through Sunday. Mobile sales establishment means a business located in a motorized vehicle or movable structure that is towed or moved by a motorized vehicle, and where all of the goods, wares, or foodstuffs that are offered for sale are contained entirely within the motorized vehicle or movable structure, but does not include a lunch truck. Report under Section 3, City of Summerside Licensing Bylaw, CS 13. The bylaw states the following. Mobile sales establishment license. A, any person or company seeking a license to operate a mobile sales establishment in the city shall make application therefore to the council. B, licenses may be granted for a mobile sales establishment to conduct business on a maximum of 2 locations in the city, and each application shall be accompanied by a letter of permission from the owners of the property on which the mobile sales establishment will be located. C, council shall allow or refuse the application based upon considerations of safety, desirability, impact on established businesses in the city, public convenience, and such other considerations as it deems appropriate. D, council may attach terms and conditions to the approval of the license if granted, including but not limited to 1, hours and days of operation, 2, health code requirements, 3, litter control, and 4, approved locations. E, the license made for a mobile sales establishment shall be valid for the calendar year in which the application is made only. A new application is required to council for each calendar year. And F, no appeal shall lie from a decision of council respecting a mobile sales establishment license. Staff comments. Mr. Arsenault is in the process of purchasing the property, therefore written permission may not be required. Mr. Arsenault operated a mobile sales establishment in 2021 on the neighboring commercial property at 476 Central Street without incident. In April 2022, Mr. Arsenault began operating a mobile sales establishment without a license at 476/480 Central Street. Mr. Arsenault was notified to cease operations until a license was obtained. Mr. Arsenault continued to operate until late May before making application and did not submit the application fee to staff. The Deputy CIO at that time, Gordon McFarland, contacted Mr. Arsenault and agreed on an application fee being submitted, and a license was issued in late June of 2022. Recommendation: staff do not support the city granting a mobile sales establishment license to the applicant, Corey Arsenault, at this property, as this property is zoned residential. To date, the city has not approved a mobile sales license on a residential zoned property. The planning board recommendation, whether carried or defeated, will be brought forward for council for a final decision. Planning board recommendation: the application from Corey Arsenault to allow a mobile sales establishment, Big Guy Burger and Fry, to operate at 480 Central Street be recommended to be approved by council. Moved by myself and seconded by Deputy Mayor Snow. If there's any questions or not, the applicant, Corey, is in here with us this evening, so if there's any context to provide, I'm sure he'll be able to provide that. If, I guess if planning board, there's a consensus to allow a speaker, it certainly would provide clarity if needed, so yeah.
If he wishes to speak before questions, I'm fine with that too, or I can start with a few questions I have, I guess, doesn't matter.
Well, maybe, did you have anything you wanted to say first? Okay.
Okay, and I don't know if it's, yeah, I guess it is sort of questions, but, so currently, as I understand it, I was gonna say Corey, but Mr. Arsenault, he owns the property beside the one that he's wanting to locate it on, and you're in negotiations or talks about purchasing that other one. Mm-hmm. In theory, if he set up there and then the sale didn't go through for whatever reason, the owner says, Like, should we still be getting permission from the current landowner regardless of whether the sale is going through or not? Like, that we've always done that in the past. I'm curious why we wouldn't still require that, even though he's in the process of getting, I just think that might muddy some water down the road that.
We certainly could. We just weren't sure when when stuff was going through. We just making a note of that if that's when
And as the agent, which would be the owner,
Okay.
has allowed me to take this through to be sure all the steps are made, and then when everything's approved and everything, because I was here a month ago, you remember, and we're doing that apartment, and when all of that is approved, then the sale goes through. So it kind of,
So it's sort of
Yeah. one kind of leads the other. First, yeah.
In theory, do you foresee there being an issue if you said to the current landowner, can I get approval to set up on your land? Until, do you know what?
Yeah, I may already have asked that, but I can certainly bring that back for sure. Yep.
And the other thing, and I totally understand what staff are saying, where we've had, not in the past, we have not approved in a residential zone, for various reasons that I can think of why we wouldn't. But I do feel this is a little bit of a different situation, seeing the person applying currently owns the property next door and is probably gonna own the one there, and then surrounding there, it's mostly commercial. So it's just a little different than some of the other ones that we would have received requesting a location in a residential zone somewhat. So those are just things running through my head, not really questions, but maybe comments and questions all together. So if there's anything you wanna.
Yeah. And I sort of had the same sort of outlook, I guess, just based on just the geography of the area being not a incredibly congested, neighborhood, big parking lot as opposed to, a driveway that can hold a couple cars. So, yeah, is there any, I know we spoke on and off today, just about some context behind the application and, residential, commercial type usage. Do you want to maybe go through what
Sure.
your plans are, just to provide a bit of clarity to everyone?
I guess the confusion on my end has been in the terminology. A month ago when I came here, step one, turn it from single use to apartment, R1 to R4. And at the same time, I've sent an application in with the payment of the fee for allowing a commercial business to operate in the same property as an apartment. Because my vision for the property, it's 1.5 acre, would be commercial businesses and sharing with an apartment for seniors. And my confusion, and it was only brought up today or yesterday, is that that's not, what is it, Lynn? I'm not sure how to explain how I've been confused in the terminology, special use versus commercial versus the rezoning. There's a whole lot of terminology I've been confused on, but I thought a month ago when I put the application in saying I'd like to have eventually a business and an apartment on the same land, and is this what I do? I was under the understanding that I was doing it the correct way. So, and I guess I wasn't, or it's still, there's a different different word to use. I'm not, restricted use, I guess, and that's where I'm under confusion. So, yep, just here to give context to the application, kind of the eventual goal of what I'd like to do with the property. So.
And when you say the property there, are you referring to the property that you currently own?
480. The one, yeah, the one
with
that's
the old.
the proposed, yes,
Yeah.
yeah.
Just in terms of your vision for the commercial component of the proposed property that you
Yep.
don't own yet, what is that? Is it just the big guy, or is
No,
there
so
other
it's-
commercial element to it?
As I wrote to Linda today, a month ago when I came, and this was public knowledge, I was contacted within a week by a real estate agent who wants to set up an office. And I originally thought, okay, well, we'll set up an office as one of the units in the apartment we're gonna build. And then I got a phone call again from a guy who wants to open basically what I had before, a gym, a commercial gym, 6,000 square feet. I said, well, maybe we can fit it. And I thought, well, we had a great season, 2021, even during COVID with the food truck, let's put it there too. And then all in one place. And so I've hired Greg Chappell, a landscape architect, to come in and help me design. We met today, how it would fit, how traffic, driveways, frontage, the whole bit. He has my vision, and we'll put it down in a plan to resubmit. But I guess with all those eventual plans, I wasn't sure which one comes first. So the food truck is the food truck, and I was telling Councillor Duran this morning, the food truck opening in, say, the next month or so as the weather turns, is what will generate money to pay for applications like this and to pay for the building permit for the apartment. That's how I kind of feed the business to keep growing. So one thing allows me to do the next one, the next one, the next one. So that's kind of the overall vision, is to start with the food truck and then eventually come back to the council with a plan of how the whole property would be developed. So hope that makes sense. A little more clarity to my vision. It's been quite a month, because it's like you go from just wanting a month ago, let's just do another seniors apartment, to having other businesses and business people call and say, can we be involved somehow? So, yeah.
For the mobile, what's it called, sales establishment, where would people park?
So I have, in the photo that's there, you'll, like where the blue is, they would, for now, as the weather is very mucky in that field, the food truck would be in blue. They would park in the 5 to 10 spaces directly in front. And then I have a landscaper who would come in about a month when the weather's better to scrape 100 feet and gravel an area for parking onto 480 on this proposed property. So they would be so I'm using my current parking lot till the weather turns for about hopefully a month, and then I guess walk 80 to 100 feet in, and that'll be all a parking area where the truck would be basically on the field where the weather's nice, when the weather's nicer. So, yeah.
Yeah, so because Corey owns the property, which is apartments, it's hypothetical. He sets up 5-6 people in the apartment start complaining that there's a food truck in front of their place. Obviously, that they complain to you,
Yeah.
but then he owns the apartment. Like, are we? I don't know. I just foresee being some complications possibly. I'm trying to make sure that we avoid any of them, if at all possible. If it's, and maybe I'm just overthinking it,
Yeah.
but I can just foresee somebody complaining, and then
Yeah,
we got-
well, I guess I definitely thought of that, because in the whole month of this sort of plan being put together, the number one thing was to not impact the tenants. They're great people. But then I walk through the field where the blue is, and I'm like, this is not gonna be ready for anyone to walk on or drive on till probably middle of May. So if I can just park where it's at now, use my asphalt parking lot 2 to 3 weeks, 5 to 10 cars on average throughout the day, and then when it's proper, it all moves into the field. And so someone, as in the butcher block beside us, someone would pull in and park in a proper business spot. But I'm just trying to get through the weather of the muckiness of about 3 to 4 weeks of May, early May. So I understand, listen, I understand that concern. That was my number one for sure, because I've got great people there right now, and I don't want to impact them at all. So
I'm not even sure if that should be our concern, because you own.
yeah,
I'm sort of trying
well,
to work
it is
through
mine. I
and-
definitely like it's the kind of question I ask myself all the time. Everything I do, will it impact? That will the driveway? Would someone, like, one thing when we were open before, no one ever parked in front of their windows. No one ever pulled up to their front door. They always parked properly, and it was quite nice because it didn't impact. I know one of the tenants who was older, she would say, I just sat out of my door all day and watched people pull in and out. It was entertainment. Not to say that was just kind of a funny comment she made, but it didn't seem to impact them before the last 2 years. So, yeah.
I kind of have a bit of a concern here. The traffic at the butcher block lately has been absolutely
Yeah.
insane.
Yeah, they're driving through our lot to get there.
And we have kind of a bottleneck here, coming out of Walker Avenue, going to down Central Street onto the highway. I can just kind of foresee accidents happening there, and I'm just a little worried about that.
Well, we were open for 11 years as a gym with 200 people a day coming in our door. And Butcher Block opened 5-6 years ago now, and we had not one accident that I'm aware of. And I have cameras that look out, and we were never asked to show footage of any accidents. There's definitely a lot of traffic there, but the small business that I have operated might have 10 vehicles, like 10 people pulling in for lunch. It's not nearly the traffic of 30 people coming to a fitness class every hour. So we have had that traffic before and has been no issue. So, yeah.
I just have a question for staff. There wasn't any mention of any issues with respect to safety. Are there any issues with respect to safety with the proposed application?
As far as for a food truck to go in that location?
Yeah, as I read it, we have to look at, basically we have to look at safety, desirability, whatever that means, or who that perspective is from, impact on businesses, public convenience, and other considerations. So yeah, I was just starting with safety.
Well, I guess we're still, I think, gonna have to look at when they come in to actually locate where they're actually gonna put it, because it was gonna be totally on that other property. They'd have to have another driveway, and I think staff comment at the time, when we looked at the rezoning of that property, we'll say the vacant property, that the driveway, I think, was to be as far north, so that it's not directly opposite Walker Avenue. So they were reviewing location, if they were gonna put something on that, if they're gonna come back and go across, if you're gonna allow that to come back to that existing location, yes, it's less than the previous use of, as he states, with the gym, with a 6-unit apartment building.
Just one other, just to clarify, the lot that they were looking at putting the mobile sales establishment on, Corey, you had that rezoned from R2 to R4. When do you plan on starting that building, just out of curiosity?
The goal is late fall, a winter build. That's when the builders are ready. But nothing's been finalized just yet. This is sort of waiting on these initial steps first. Yeah. I would love to have the same plan as last year, is to build in the winter and the workers work indoors for the winter. So the builders seem quite excited for that prospect to work indoors, so for the winter.
Councillor Coleman?
Corey, I just also have a couple of questions. The one around the Butcher's Block. I know that they have increased traffic.
Yep.
And just as Councillor Barb has indicated, there is an awful lot of traffic entering and exiting into that area. And again, it's on a very, very busy street, Central. So that's where my concern lies. And the fact that, I mean, we're trying to follow the residential aspect of the policy. And I think what we could also run into is if, other builders, developers are watching this, where we could possibly be opening up something that there's going to be challenge. And I think that's why we're just asking the question.
I understand. And this is all, I didn't realize it was a meeting tonight, so I'm kind of a bit unprepared. I only saw someone said, hey, you're on tomorrow's meeting. I said, for what? I had no idea. So I didn't know this was coming up. I assumed from a month ago, the application for the commercial side of that property would be coming up sooner, but I guess it doesn't work that way. So that's I don't intend to remain a residential. I guess I've explained my vision of the long-term, kind of a combination, and that's where I just don't know how to word it or apply for it to have both in the same place. I guess that's kind of my concern, or I'm unclear. So yeah.
Just because I've heard it a number of times, so can we make sure we have some discussions with Corey and figure out, because I'm hearing he's unsure, and I don't know how unsure he is, or what. I'm starting to get confused, I guess, because we're talking, it was rezoned residential and then we're commercial, and So I assume you're wanting on one lot, a building that has commercial and residential in that one building,
That was my goal. No, well, in the same lot.
in the same lot.
Possibly two different
buil-
buildings. Eventually developing the whole 1.5 acre to have both a commercial
Okay,
build,
I
commercial
can
and a.
interject there, and that's some of the confusion, is that Councillor McDougall's not here. When we were going through the resolution for our zoning, for the R2 or the R4, we were clear when we sent out the notification, here's what we're putting in. It was gonna go from R2, same building as that I have there, that was what was stated. Now we're looking at, and I know things evolve, but when we send out notification to people about that process, here's what we were told at that time. And in order to meet the timelines, to make stuff go efficient and fast and meet other deadlines, that's what we went forward with. That's what's being proposed. Then, as Mr. Arsenault said, I had discussions about going to put a commercial component in there. Okay, well, we've already have our ad out saying this is what's going in there. This is what we're advertising to people. Staff then went back and said, okay, we can accommodate not changing the whole thing to commercial, but coming up with a specific use that you want to do in one unit of that building. One of the councillors at the meeting when we went through that process says, is this going to be what's going to happen out in the back of the building? Can't do anything out there because of the sewer lines, and we showed just the lines out back, and it was going to be one building. So I know it evolves, but we're still trying to deal with, we went from R2 to R4, okay, that's what we've gone through, and it was only going to be one building, and now we're going to be into possibly two buildings and one residential and other commercial uses in the other buildings, which are going to provide challenges on meeting your own current rules and regulations. Things evolve, as we know, because they're not all set at the time, but we process what we have at the time, and that's what gets sent out so that the people are informed and aware.
So, if he is planning to do residential, commercial, basically it's gonna have to come back to council again to get rezoned appropriately or proper approvals. Correct?
Yeah, so the first plan we got was, that Corey submitted was the duplicate of the building that's there.
Right.
Okay, just 6 units
Yep.
mirrored onto the next property. Then he informed me that he would like to have one of those units to be used as a commercial use. So you can't do that unless you're gonna make half of the building commercial or whatever. It doesn't fit to any specific zone. So suggested that, gave him the option to either withdraw that application until he was clear on what exactly was allowed or what his proposed plan was, or you can apply for a restricted use for the commercial component. So the restricted use has to be a specific use. It can't just say commercial. Right? It has to be a specific use, if a restricted use. So it has to be like a personal service shop or
Right.
a something or other. So that was how it was addressed. And then, and again, there was no mention of the mobile sales establishment at that point. But then the application for that came in after the fact.
Okay.
And just so I'm clear, when we're considering rezoning applications, we are simply looking at the zoning itself. We're really not supposed to be looking at what buildings are going there or anything like that. We are simply, so when that came forward, it was an R2 to an R4 zoning application. Then a subsequent application could be made for restrictive use. We're not supposed to, I don't think, look at what building or gym or apartment. I know we do because there's some interest in that, and it helps get a better understanding, but just so I'm clear that we made that decision based on the zoning piece. I just want to say a couple of things. One, I think Councillor Snow's absolutely right with respect. There has to be, shall be accompanied letter of permission by the owners of the property. If Mr. Arsenault is not the owner of the property, I don't think he can proceed without a letter, whether or not you're going to buy it down the road or not. That one to me is pretty clear. My thoughts here on the safety, I don't really hear any issues with respect to safety. The impact on established businesses in the city, unless someone's got some thoughts on that, I don't see how that is affected at all. Public convenience, for me, again, I'm just going through my checklist. I don't have any issues with public convenience. The desirability, I think, is worth, it could be helpful to know, to make sure that the residents are comfortable with it, given the situation. I don't know how we
I believe
consider the design.
I believe when letters go out, that it comes to me and it comes to the butcher block. I think we're the only ones that are residents within the 100 feet, I believe. I think, so.
They go to property owner, because we couldn't know if any one of you might be a tenant in that building. We have no record of that, so it goes to the actual listed property owner. So we wouldn't have any means of tenanting.
Let's
And
be
they-
honest, as somebody living in Mr. Arsenault's building and the state of apartments right now in the city, and everyone's probably not gonna go and complain, or, they're in a tough position that way, but he does own the property too, so it's just looking for feedback from his residents when it's his building that's a difficult situation.
Yeah, words like desirability are difficult. As I said earlier, especially when we don't know whose desirability we're supposed to be considering there. That's my general comments here. I don't have any other considerations.
Okay. So I guess, although it's never been done before, allowing, I'll speak specifically a mobile sales establishment, it's never been allowed in a residential zoned lot. So if this is approved, it would be setting a precedent. But still, these applications come to us on a case by case. So we do look at the different components and things on a case by case. So even if we were to, look at the details of this, and if we were to approve it, that doesn't necessarily mean we need to approve the next one or the next one or the next one. It all depends on, the geography and the traffic and, of course, the desirability. But so just looking at that, I mean, this isn't, if this was, say, for example, an R1 single-family dwelling on Water Street where there's a driveway that holds 2 cars, I would be very hesitant in looking at this. But in this case, which, as I just stated, we do these on a case by case, even if it is the first time in a residential, the geography, the layout, the parking availability, to me, it makes perfectly fine sense to support it. As a planning board member, I see that and I support it. So I guess if there's nothing else, we'll just move on and ask for the planning board vote, and council will be the ones with the final say. And did you, Councilor McColman?
I
wanna
do,
add
I'm
something?
not on planning board.
Well, that's okay.
But I guess I'm looking at it, when you speak of precedent, I know that is very, very important. But I also am listening to what our staff in the department are saying about when the original application came in, and I mean this with all due respect, Corey, I'm just trying to get this through my head too. But the application was from an R2 to an R4. And what I'm hearing kind of refreshing my mind that the staff did send that information out to let people know and advise people that's what it was. I think there is a caution and a responsibility on our part as a city that we can't be putting the staff in those kinds of situations and changing the boundary lines of the policy. And I just feel it's very important to speak that.
Yeah, okay.
To put more thought around that.
And just also to clarify, this is strictly this evening for the mobile food establishment. This is not, we're not dealing with the mixed use of any projected building or anything. This is strictly just on the mobile sales establishment, which again has never to this point been allowed in a residential zone. But the mixed use building, that's an application or in a meeting for a different day. So yeah.
Just to clarify, we're talking about a residential zone that doesn't have any residences on it,
Yes.
in which there are no intent to have any residences.
But still, I mean,
at this point
the
in time.
bylaw doesn't care whether there's residents on it or not. It's the designation of the zone.
What we're proposing though, Mr. Mayor, is that we're gonna park and access through the existing residential property for this one, where we're putting the mobile. That's the residential overlap that exists as well as what's proposed for the we're not talking about the 5 or 6 that may happen in the future. It's right now we're proposing to come in through the existing lot, park on that lot that he owns, that it would, if someone else owned it, we'd be saying you still need to get permission, written permission from them as well to give access to your food truck as well as where they're gonna park until weather permits to get on your own, as well as create an access off of Walker, own independently. So there is an existing.
If people are parking in the existing residential, the lot to the south, is that part of the business? Would that be part of the conducting a business in that property?
And that's what we're saying, is that commercial component, or the food truck, whatever we're calling it, is gonna be occupying on his existing residential lot, when really we're saying it's gonna be on the new north lot, fully contained on. Like if someone's applying to put, if I wanna put a truck, it's where is it going and where it's gonna be fully contained on that property, this is gonna be operating on both properties, and one of the two are residential now, developed. And thankfully he owns both, so you're not asking to get permission to go across the existing one as well.
Yeah, I guess my just question is by parking there, is that lot to the south then involved in commercial activity? You follow?
I guess they're gaining access to the commercial activity, is that what you mean, as far as on the south lot?
Yeah, just
Yeah.
whether that's an extension of commercial activity.
I would say that's how they're gaining access to and from. It's going to be as you mentioned, it's not going to be a long stay. It's going to be going to get my food, maybe eat it, and go and come and go. That's going to be the trip
And
generation.
only until the seasons.
That's my hope. Yep.
Yeah.
Yeah.
Yep.
Just to also re-note, the mobile sales establishment component, of course, is temporary, if that's a good word to use. It's seasonal, and it's renewable, but, if things were to happen, go off the rails, whatever, December 31st comes along, that's it. This isn't a guarantee for next year, so.
In theory, if things go off the rail June 1st, the permit can be pulled, correct?
You can attach, correct me if I'm wrong, stipulations to any conditions. The council may attach terms and conditions to the approval of the license. Hours, health code, litter control, approved locations.
So, but we provide, just in general, a mobile sales establishment permit to whoever. A month in, we're having issue upon issue with that establishment, and I'm not talking about court,
Yeah.
I'm just talking in general.
General.
Do we not have the right to pull that permit? They're allowed to operate all summer? I guess I'm saying, shouldn't we have the right to pull that permit if it's causing issues within the city?
There would be steps taken to try and rectify the issues and make them aware of them, and allow them time to, and then we come back to you and say, check with legal and what your abilities are to do with your bylaw. But we would certainly make efforts. We don't have very many of them to say, this is what's going on this property. We're getting complaints. Can you clean that up? Your garbage or your grease is dripping somewhere.
Okay.
Hours of operation or something, and provide them.
Anything else? Anyone? Did you want to add anything else, Corey, or?
I think I've explained. I hope it's clearer now. As I talk about it more today, I explain. Again, I was a little bit caught off guard about the meeting tonight. I'm glad you invited me. I'm glad I came. I thought it was later in the evening, so I couldn't come. But I'm glad I had a chance to explain it, because it, again, makes more sense when it's kind of laid out of the sort of the long-term vision. This is just sort of step one, and I guess I might have applied in the wrong order, or I'm still not quite sure what I've done wrong. But I guess for the long-term vision, you know what it is now. I'm here to follow all the correct steps so that I can make it happen. So, yeah.
Okay. So for this evening, the mobile sales establishment component is what we'll deal with tonight. So that will be sent to council, whether planning board recommends or not, and that will be the April monthly meeting. So that'll be the third Monday in April, where council will make a yay or nay, and that'll be it.
I just have a quick question, and you probably answered this, but the property to the north of the proposed location there is zoned R4, and this is a permitted use under R4? would there need a, because I know we're talking about a license, but I'm also,
I think there's home-based businesses that are permitted uses.
so would it require a separate application, or would the granting of the license?
So the license, the mobile sales establishment license, really is to do a bit with land use. But if you read the uses under an R4 zone, a takeout wouldn't be one of them, which this is. So in the past, council has elected or preferred to stay with commercial-based properties, just because those uses are allowed in those zones.
So if this was if there was not a mobile sales established license, if Mr. Arsenault just wanted to put a burger shop, bricks and mortar, we'd be rezoning the property, but we don't have to in this case.
We haven't done them, so we haven't gotten to that point.
Right, yeah, I just wonder if you'd have to. No. I just don't understand how you can you can sort of use a mobile sales establishment license to do something you otherwise wouldn't be permitted to under the zoning requirements of that property. Without, I don't know, I just think you'd have to have both applications in to have a permission to use whatever, if it's a restricted use, I'm not sure, for that business. As well as to me, the license is independent of the land to an extent. The license is to operate the mobile food establishment. It's mobile by nature. The second issue to me is whether or not it's conforming to the current zoning. So is it not conforming to the current zoning?
It's not conforming to the current zoning. But again, it's not a permanent structure. So it's a little bit different in that nature that, so basically, we've asked, some of the people we've had it in the past where people have asked them to be on city lands and all of those types of things. Again, we have basically stayed with keeping them on commercial properties. That's what the consensus has been.
Have we ever had it the other way around with mobile residential units on commercial properties? A house on a trailer, or something like that. Anything that would be similar?
I think there's a mobile home where people can park something for 30. Yeah, there is there's a separate category we have to go through where you're allowed to have a park for 30 days. There's a time limit on how long a mobile home can be parked somewhere, like an RV, or I'd have to get into the details of what that is, but they are in other overlapping zones perhaps, but there's a time frame and how long it could be there. I think it's even in your residential lot, if you had somebody come in to visit you and they could stay there for 30 days and in-laws could come and stay in the camper and be on your property and then go about their ways, but not for 6 months.
Now, how long can the in-laws stay in the house? Just asking for a friend.
Case by case basis.
There's indications that there might be something that we may have to revisit with bylaw policy review maybe down the road, but I guess, for tonight, as we try to move on the mobile sales establishment, I'll read it again and we'll go from there. The application from, is there anything else? And we'll just move to take it to council and then.
I guess the only last thing, and I mentioned it and then Dan mentioned it, the letter from the landowner, I think, needs to be part of any consideration on my end. So I don't know if I add that, we add that in at this point, or
Probably the
when we
resolution
get to
at council.
council meeting, but for me, I wouldn't want to see it move forward from this point without having approval from the landowner at the time of the final decision, if that makes sense.
Yeah, so we can move to bring it to council and then maybe we can word the resolution at council pending a letter, if council decides to approve.
it says the application shall be accompanied by a letter, so the letter should come prior to the application coming before council. Doesn't say to, planning board, but yeah, before final decision.
Okay. And it sounds like that probably won't be,
I have two of them,
problem.
I have two written already,
okay,
for the two applications, yeah.
okay.
Yeah.
Okay, the planning board recommendation. And again, this is just a recommendation to bring it to council. This isn't necessarily a recommendation to support. The application from Corey Arsenault to allow a mobile sales establishment, Big Guy Burger and Fry, to operate at 480 Central Street, be recommended to be approved by council. And that will be the third Monday in April at 6:30 PM. Usually those meetings start, so. The wording on that almost makes it look like it is being recommended to be approved by council, so I don't know if that's the proper wording at this point, but it is just a recommendation, it's not a resolution, so.
Could I just ask
No,
one
it's
question?
it's a recommendation from planning board to council. That's why it's in you're making a recommend to approve it, and then council can either disagree with that recommendation, but this smaller group of planning board is to make recommendations to the entire group of
Yeah.
council.
But it says be recommended to be approved by council,
Right, so if,
so it's almost like we're endorsing it.
so if we're recommending it be approved, then, see, we went through this so many times over the years, it's not even funny. But if we say nay, it still goes to council.
Absolutely, it goes to
for
council still.
final decision.
It
It's
just-
just whether or not it's going with the recommendation from us to be approved
Yeah.
or not.
Yeah. Councilor McCollum,
I'm sorry.
don't be sorry.
I just want to make a point of order. We've already mentioned about that it is important that a letter from the person that has indicated that they're in favor. I'm wondering if that wording should not be somehow included in that recommendation, pending the letter being received on the property. Because then that gives it a very clean clarification of what we've all talked about tonight. I'm not trying to be cumbersome, but it's not there, and maybe it should be there.
I can-
Isn't that when council do it, when council all votes on it, on the 17th though? Then don't we attach it at that time?
What we've done in the past is we have not issued the license until we receive the written permission letter.
That's what I'm talking about.
Now, whether that's before council approves it or not, but it's a condition of it that they have to provide that letter.
So that's standard.
Okay, and I
Practice.
guess just point of order, I'm just sort of echoing what our mayor has said, that it's important, to have that documentation in place before we bring it forward to another vote.
And I just wanted to clarify something for Corey. The two documents that you have submitted thus far, one for the restricted use and one for the rezoning, were designation of agent forms from the owner to allow you to carry out those two processes. We don't have any written permission from you currently, from the current property owner for this application. So you would need to obtain that.
I understand, but yes, I will absolutely get a letter that says, but she's applied as an agent with me. So she's signing the same form that I'm applying to do, so I will come back with an actual different form. Yep, for sure. Yep.
Okay. Still lots of sunlight left. Go ahead.
Yeah, just a question in terms of attaching any terms and conditions, is that done here, or we would do that, I guess we do that at council? To me, the parking thing is, I just wouldn't want to see people all through July and August, parking along that space from a desirability from residents in area. If it's intended to be in that northern property. Anyway, but we can do that, or council can do that.
In C and D, it says council shall and council may, so I guess that's,
Okay. Planning board recommendation, the application from Corey Arsenault to allow a mobile sales establishment, Big Guy Burger and Fry, to operate at 480 Central Street be recommended to be approved by council, moved by myself and seconded by Deputy Mayor Snow. All in favor of the planning board, say aye.
Aye.
Aye. Carried. And that is everything for this evening. Thank
Thank
you,
you,
Corey,
everyone.
for coming
Thank
in
you,
to
Corey.
provide some of that.
Glad to explain it. Thank you.
Thank you, Councillor Duran, for your excellent work again as Chair of Planning Board. That being everything, I said we'd be done by 6. It's 5:55. We'll adjourn tonight's meeting. Thanks, everybody.